How long is it going to take? Because it's take us.
That I don't know. I've had them on the way since Maggie first called me. They were toned right away.
Okay.
All right, but I think they're coming. Hang on 1 minute. Let me check. They're coming from somewhere on Belt Highway in Ruffin. Okay, that's where their station is.
Thank you.
All right, but like I said, if something changes, call me back.
Yes, sir.
Okay.
Well, 911 calls are tricky because you don't want to assume anything, but I don't know. Those two people on the call didn't seem too enthused about answering questions or have much compassion for the victim. Maybe, maybe not. I don't know. Difficult. Let's talk to someone who knows. Former prosecutor and former assistant state attorney Sue-Ann Robinson. You listen to that 911 call, Sue-Ann, and they are analyzed, are they not, in any trial at any time because people think that people should react a certain way. And frankly, in this one, there didn't seem to be a lot of, oh my gosh, what can we do? What can we do? It was more of like, stop asking us questions, lady. Your thoughts on the importance of behavior in a call like that?
Right. I think you're absolutely correct. I think at first blush, obviously, the way that they're responding and how they don't seem to have much compassion in their speaking, the fact that Maggie doesn't even know her own housekeeper's actual age. I think all of those things are going to be evaluated and analyzed, not only by the internet police that are following this case, but also by the jury when it eventually gets there. I think this is one of those cases that has all the good elements, right? It has secrets, it has corruption, it has a very powerful rich family, essentially unraveling and falling from grace. And I think that the fact that this 911 call kind of gives you insight into how they kind of interrelate with each other and interrelate in an emergency situation.
Mm-hmm. Absolutely. Fascinating case. We want to thank Sue-Ann Robinson for her expertise and her valuable time this morning. Appreciate it. Have a wonderful day, Sue-Ann. We're going to step aside, take a break. When we come back, we'll go live to Minnesota. Jury selection process in Potter continues right after this. There's the seal. Be right back. Top of the hour. Welcome back to Court TV Live. Day 3 of jury selection is about to get underway in the trial of former Minnesota police officer Kim Potter. We'll take you live into the courtroom as soon as Judge Chu gets on the bench. 9 of the 12 jurors and 2 alternates have already been selected. Is today the day that the jury will be seated in Minneapolis? We'll find out together as it starts at any moment. Opening statements are set for next Wednesday, December 8th, but because jury selection is moving faster than anticipated, the judge mentioned yesterday she'd like to have the attorneys at least think about starting earlier than that. The former Minnesota police officer is accused of killing Daunte Wright after pulling out a gun instead of a taser. She's facing 2 counts of manslaughter. Joining us now, jury consultant and human behavior expert Susan Constantine. She's with us from Orlando, Florida. And joining our discussion, retired federal prosecutor Robert Sanders is in New Haven, Connecticut. Good morning to you, Robert. We've been talking about this jury selection process, the fact that the state of Minnesota is out of preemptory strikes. The defense still has 3 to go, and that makes it a bit of a chess match that we're going to be watching play out. As a former prosecutor, how naked do you feel when you don't have strikes and they've got 3?
Well, at the end of the day, you're looking for a jury of the peers of the individual on trial and representative of the community. And, of course, you still have the ability to strike people for cause. So if someone is really unrepresentative of the community or has a bias that should not be allowed to be in part of the jury pool, you will often have the judge and even the defense counsel agree that that individual should be stricken for cause. Now, yes, the state still has used all 3 of his, and defense still has 3 left. That gives them an advantage to be able to shape the jury to their liking. And you just have to walk with that as a prosecutor and see if you can get the best jurors for your side of the case.
Susan, we don't get to hear the arguments when one of the sides wants Judge Chu to strike for cause because they have the headsets and they do this sort of sidebar with the individual still in the courtroom. It makes it work a little quicker, but the downside is we don't get to hear the arguments. However, we should be looking for some of that taking place today, right? Because to Robert's point, if the state has someone who they would love to bounce, even if it's iffy, they're going to go all in on that argument for Judge Chu to step in and strike.
Yes, that's true, because that's the only thing that they have left, because they've already used all their preemptory strikes. And I agree with your other guest. It's a very vulnerable place to be, though, because they've already used them all up. So now they're going to use their other, to try to, strike them for cause, have them removed for cause. But they have to have a very strong argument for that to happen. And the only thing that I can think of is the state must have felt that the jurors that they've already used their preemptory strikes were so dangerous that they use them all up front, because we are only we're still like 5 jurors away. I think we've got 3 more, and then 2 alternates that we have to select yet. That could happen today. Not having the advantage of being able to go back and backstrike or remove someone that you found now in the remaining part of that jury pool, so to speak, there is really putting, in my personal opinion as a trial consultant, that wouldn't have been a move that I would have taken this early on.
Robert, let's talk about something else that came up in this case. The defense has articulated to at least a couple of the prospective jurors that the defendant's going to take the stand. They let the cat out of the bag early before even openings, and Judge Chu inquired already with the defendant. You realize, that this is up to you, your choice. We see that usually near the end of trial after the state's case. Your thoughts on the strategy of letting prospective jurors know, hey, you're going to hear from the defendant, because now you're tied to it.
Well, they're already going to hear from the defendant. There's a video. And in the video, it's clear the defendant shoots and kills Mr. Wright. There's no doubt about that. Now, the defendant is also yelling, taser, 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 indicating that she was reaching for one weapon and grabbed another, indicating a mistake. What was the level of that mistake? Well, who can explain that? The defendant can. And the jurors are going to want to know what was going on in her mind. What was she thinking about? Why did she do what she did? The only way that comes out is through her own words.
Susan, you're a human behavior expert. The idea as a juror, a potential juror, knowing that, okay, we're going to hear from the defendant, I'm definitely going to hear from the defendant, that is a tactic, is it not, that defense can use to get into someone's mind? Because now they're like, all right, I'm hearing some evidence against this person, but I got to keep in mind, I'm going to hear from the defendant. That can work to your advantage.
Yeah, and that's what we call anchoring. You're already anchoring into the subconscious mind that's what their expectation. That's your expectation to see that. Think about like a trailer to a movie, right? You're getting the suspense of the movie, and you know what is about to happen, but you're not really quite sure. So it's almost like a preview to the movie. So it's helping to, I guess, that they get them enticed that they're going to hear what the defendant, and also to keep in mind, during the jury selection, I'm wondering if the judge may be thinking that it was a way to be able to keep more people on the jury. So more people will be less apt to want to get out of jury selection, because the anticipation that they're actually going to hear from the defendant herself.
Robert, does race matter in this case? I mean, you have a 20-year-old who died as a result of the shooting here. Yes, the cop is white. To what extent does race permeate this case? And maybe it doesn't. Maybe it's just about a mistake or your feelings about police less than race. Your thoughts?
Well, for the jurors, there's an issue about feelings about police, about whether or not they're honorable in their actions, and how we should consider what they say when she gets on the stand. But to your initial question about whether race permeates this. So this young man was stopped for 2 reasons. He had expired tags, but the other reason was he had an air freshener hanging from his rearview mirror. Can I add another one? He was black, driving while black. That's got to be an underlying stop this guy issue. And if you don't think that, then I don't think you're being reasonable. So yeah, there's race here. It's on the front end. Now, after they pulled him over for a legitimate reason, which was the tags, I don't consider the device hanging from his rearview mirror to be a legitimate reason for a stop. Whether or not it violates the law of the state of Minnesota, it's still a law that you generally would not have enforced against an individual driving down the street if there were real crimes happening in your community. So looking at that, yes, there's race there. How it comes out at the trial, that's really going to be on the prosecutors. And we look back in the Aubrey trial and Ahmaud Aubrey trial, and we think that the prosecutors lowballed race for good reason based on the community in which the jurors are coming from. Is that the same factor here? I don't think it's to the same extent, but anytime you have a white officer kill a black man, there's a piece of it there.
Yeah, and Susan, to that point, it's a nuanced strategy. It has to be from the state in this case to bring it up in a way that they believe will be acknowledged, but they have to be careful, right?
Yeah, they have to be super careful because the current climate that's happening. And remember that we had the Floyd case happening right at the same time. And to speak to your other guest, and I agree with him too, is that when you're looking at like the Avery case, we had 11 whites that convicted the three gentlemen that killed that young black man. I think that people in general, and not generalizing with race, are intolerant of racial bias. I mean, they're just over race with killing anyone because of their skin color. So I think that that's going to play into this jury pool. We have a quite diverse group. And so it'll be interesting how it all plays out. But to speak to this gentleman's point is I think that race will be a piece of the pie. Yeah.
We'll see the rest of jury selection play out in just a minute. We're going to step aside, take a break. We understand Judge Chu did come into the courtroom and has summoned the attorneys into chambers for a discussion. When that is completed, we do expect that day 3 of jury selection will continue, and we'll watch it live right here on Court TV. Be back right after this. Stay with us. Welcome back to Court TV Live on this Thursday. We're waiting for Judge Chu to take the bench and the jury selection process to continue, day 3 of the process to continue in downtown Minneapolis in Hennepin County, Minnesota, where Kim Potter is standing trial. She is the former police officer that is standing trial for 2 counts of manslaughter after she shot and killed 20-year-old Daunte Wright during a traffic stop. She claims that she reached for her taser, and instead of grabbing her taser, she grabbed her gun and shot and killed the 20-year-old, meaning to tase him when he started to flee after they tried to take him into custody. Still with us, jury consultant and human behavior expert Susan Constantine is in Orlando, Florida, and retired federal prosecutor Robert Sanders is in New Haven, Connecticut. Robert, we were talking earlier about the fact that this traffic stop should raise eyebrows with members of the jury when it's articulated to the in court. We're assuming that it's going to be in the openings and it's going to be out of the gate in the case in chief of the state of Minnesota, because there were a couple things going on. The tags were expired, but this was during COVID when people could not get to the DMV. So it adds another layer of complexity in terms of pulling someone over for that. And then you add the air freshener and the immediate reaction to anybody. It may be a law in Minnesota, but the idea that you pull someone over for an air freshener hanging from their rearview mirror is absolutely ridiculous, and that will raise eyebrows. But fast forward now to when they call in the plate and they call in the individual and there's a warrant for his arrest. Do you think that will end up trumping, because that's what the defense wants, the idea of the person, the juror, thinking, oh, they never should have pulled him over, but there was a warrant for his arrest? Now I understand why they took him into custody. Your thoughts?
Well, the presentation is going to determine that. So the prosecutors are going to have to say, look, there were some mistakes made here. in terms of the initial stop. The initial stop was then, followed up with, there was a warrant here. And, by the way, if we add in the initial stop and the negligence shown by the defendant in using her firearm, that outweighs many of the other things the defense is going to bring to the table. This stop, pretextual stop, I'll call it that, because in America, African Americans are stopped often for reasons not beyond the fact that they just are African American. We are talking about a time when, yes, in fact, the tags were often not being renewed. That was a phenomenon across the country. What normally would have happened was you arrive up and say, yeah, you get in, get your tags renewed. We need to get that done. And oh, by the way, take that air freshener down. Bye-bye. But there are warrants. So now the situation changes. And now the police have a different posture. They're no longer talking to just a motorist on the side of the road who happens to be black, who they stop for protectional reasons. Now they're talking to a motorist who stopped for protective reasons, who now has warrants that puts him in another category. And oh, by the way, he's still black.
Yeah. Susan, what juror do you want then to be able to consume this? And how much does the fact that in Minnesota, in Minneapolis, is what happened with George Floyd and the aftermath of that? Because we've seen this play out during this voir dire process. These people are still very scarred, if you will, and very sensitive to the conduct of police. I mean, they had a vote in Minneapolis about defunding the police. It got to that level. What juror do you want? Do you want the rule follower who's the older white guy, the classic stereotypical juror in a case like this, or is it more nuanced because of the shared experience of what's happened in Hennepin County?
Yeah, I think that this creates a very visceral experience for jurors because of what's happened over there with the George Floyd case. So when I am selecting, or I would call deselecting a jury, again, it goes back to we're trying to sift out which ones are more fair and impartial. So how do you figure that out? And that is what happens in voir dire. Were some of the jurors asking questions maybe if they were supporting any other organizations like Black Lives Matter? Do they already have an opinion about protesting? These kind of things are going to come out. And what I'm listening to and what I really found very interesting is listening to the responses of the potential jurors that were being questioned. Their pauses, their tone. Their tone, you can tell whether there's anger behind it or if they're frustrated. You can almost visualize what their facial expression looks like when they're saying things, when they're answering questions. So what I am looking for are those, and I know we keep hearing this over and over again, those that can set their own opinions aside and look at the evidence of the case. So how do you then find those? And I am looking for people that are able to look at things from both sides of the perspective. They may have some view, but they're open to opposing viewpoints. And just in their questioning and how they're answering can give you a lot of insight about how they think and process information, because everyone, I don't care who they are, comes with some form of bias. The question is, what is the bias?
And Robert, another part of the equation there on detecting the bias is the questionnaire. And we've seen juror after juror, potential juror after potential juror, come in and be confronted with those answers that they had, that they'd written in the questionnaire, in their kitchen with a cup of coffee, not thinking they'd ever actually make it to this point. And that's the real raw stuff. And they're almost, a lot of the jurors, you could tell, we can't see them, but you could hear it in their voices. They're kind of like, oh yeah, I forgot I wrote that. And now here I am, I have to defend it. That is a real window, is it not, into potential jurors' mindset, because they're in the comfort of their home, not thinking it's ever going to be read by anybody.
Right. And, at the time you fill out that jury questionnaire, honestly answering is what we want the society to do. And those honest answers now need to be tested by both sides to determine whether or not that individual has a bias that would keep them from off the jury. Now, I saw earlier in the jury selection, there was some pointed questions about whether or not they were in support of Black Lives Matter, whether they're in support of Blue Lives Matter. People were bounced, removed from the jury in the cause process or preemptive process as some of those answers came through. And again, you start out with the government no longer has any preemptive challenges. They'll be looking now for things that demonstrate cause, that fall along those lines, and they'll be picking through those documents to see if there's something in there that shows up that will help them present that point to the judge.
Susan, can you tell right away if there's a potential juror wants to be on a jury in that when asked, could you be fair and impartial and put it, oh, yes, I can absolutely put it behind me. That enthusiasm that comes out.
Yes. And also they're more in an action stance or leaning forward. They're usually bobbing their head up and down, like they're always answering the question before it's asked. And then there's this high breathing up in the chest. That excitability you will be able to sense. So I want to speak to something though. You brought up about the juror questionnaire, and I've been trained in statement analysis, and what I look for and how a person answers the question. When they're asked a question, what are the first few words that are coming out on their answer? It is so important. People really, and I don't know about all attorneys, but this is why they need a trial consultant in cases like this, that are trained in how to read language, statement analysis, because what a person puts on paper gives you insight into their subconscious, what they think and what they feel. Those words, those very first words that come out, give you massive information about that person's personality and past experiences.
Fascinating. Robert, do you want or do you discount someone who wants to be on the jury? Or is it a case-by-case situation? If you feel like, oh, this person really wants on, do you necessarily say no? Or what's your thought process usually?
I'm wary of the person who wants to jump out of their seat and jump into the pan. I want the person who is there because, I feel it's my duty to do this thing. I really don't want to do this thing. I'd rather be someplace else. But if not me, then who? That's the person I want. My former teaching partner in DeWar College used to talk about people who jump out of their seat with their hands raised for every question that's asked. That's not the person you want.
Yeah, it's a fascinating process to watch play out. If you're just joining us, we are waiting for Judge Chu to take the bench and for day 3 of jury selection to begin in the case in Minneapolis there that we've been following against Kim Potter. She's facing 2 manslaughter charges, 1st degree and 2nd degree, for the death of Daunte Wright, a 20-year-old that was stopped during a traffic stop in Brooklyn Center, Minnesota, just outside Minneapolis. She claims she reached for her taser, yelled taser, taser, taser as he was starting to flee, and shot him with her service weapon. Let's take a look back at all of this case, including that crucial body camera video. Here is Court TV legal correspondent Chanley Painter.
It is, Your Honor.
While all eyes were on Derek Chauvin, the Minneapolis police officer on trial for murder in the death of George Floyd, another black man was killed by a white police officer. Kim Potter, working for a neighboring police department, shot and killed Daunte Wright earlier this year. Protest erupted over the death of 20-year-old Daunte Wright. He was killed during a traffic stop in the city of Brooklyn Center, just 10 miles north of Minneapolis.
Let me be clear. We will get to the bottom of this. We will do all that is within our power to make sure that justice is done for Daunte Wright.
In a bid to quell the growing outrage over the shooting, police released body cam footage of the incident.
I felt the community needed to know what happened. They needed to see it. I needed to be transparent, and I want to be forthright. I due respect to Daunte as well.
The footage captured veteran police officer Kim Potter shooting Wright instead of tasing him. Potter says the shooting was an accident. She mistook her firearm for her taser and shot Wright while he was allegedly resisting arrest. The incident has raised questions about racial profiling and the use of force by police.
Is it the rules are set aside when you're really being targeted for driving while black?
Police say Wright was stopped for expired tags, but attempted to detain him when they discovered an outstanding warrant for his arrest.
He didn't deserve this. He was so loved by everybody.
Officer Potter resigned from the force 2 days after the shooting and was charged with second-degree manslaughter.
Trust and cooperation must be earned.
Minnesota Attorney General Keith Ellison led the team that won a conviction in the Chauvin case and is also leading the prosecution against Potter. He added the more serious charge of first-degree manslaughter. If convicted of the top count, Potter could spend up to 15 years in prison. Daunte Wright's family says it's praying for justice.
The joy that Junior brought to Daunte's life was truly amazing. He was so happy and so proud, and he always said he couldn't wait to make his son proud.
All right, we're going to step aside, take a break. When we come back, day 3 of jury selection in the case against Kim Potter. Stay with us. Be right back. Welcome back to Court TV Live and our continuing coverage of jury selection in the state of Minnesota versus Kim Potter. She's the former police officer who drew her service weapon instead of her taser and shot and killed 20-year-old Daunte Wright earlier this year. We had an extended sort of delay this morning where all the parties were back in Judge Chu's chambers. She's back on the bench now, and she's just called for the next group of potential jurors to come into the courtroom. And as soon as they do so, we will go in live for this day 3 of jury selection. So far, 9 jurors have been selected to the panel. The goal is to get to 14, 12 jurors and 2 alternate jurors. And that process will continue today. At this point, opening statements are scheduled for Wednesday of next week. However, if a jury is selected today, Judge Chu articulated that she would be open to starting with opening statements earlier, moving it up a bit because it is bumping up to the Christmas holiday, which is a factor. Susan Constantine and Robert Sanders are still with us. When you're looking at a jury, Susan, and it's your task to find the good ones and the bad ones, do you evaluate their mannerisms, just their body movements from the moment they walk in? Right now, there'll be a pool of it's been 5 to 7 at a time that are asked questions. How much evaluating are you doing just through body language?
A lot. 93% of how we communicate is through nonverbal. So I am analyzing all of their movements, when they're putting or when they're moving, like what they call anchor shift. Someone that has a strong opinion about something, we would just kind of get up and they might shift their chair at a certain point. And I'm tying it into what was asked, what question was asked, to seeing who's moving. I'm also looking at blinking rate. When there's high level of anxiety or you have a strong opinion about something, you'll start to see their eyes blinking more rapidly. I'm watching to see if I'm seeing any sort of smirks or contempt, which is like a mouth movement that moves to the side slightly. That's very fast and fleeting. Contempt, which is moral superiority, which could indicate what they're hearing they don't agree with. The other thing I'm looking for is little micro shoulder shrugs, just on one shoulder, not the other one, not the very big ones. So nonverbal communication is a major part of my evaluation because I think that your body speaks louder than words, and what you're thinking and feeling leaks out through your nonverbal communication. And then we have how they answer the question. So then you sync that together. So I do, in my mind, what I call a 3-pronged test. What they're saying, does it sync up with their words? And what is their expressions on their face? And then how did they phrase it, their voice, their tonality, etc. And I'm putting that together. So I have a system in which I use, which is evaluating emotional responses, body language movements. And so those are the things that I'm looking at to see how they're responding. What were the movements that caused them to respond? a shift or a change from their baseline. So I am doing what we call a scan analysis. I'm scanning from top of their head to the further up to here, because keep in mind, you're not seeing their feet. And it also becomes much more different, a little bit more difficult when they're wearing a mask. So I did a piece on the masked juror. And when you're looking at masked jurors, you can't see their mouth, right? You can only see just maybe the top part of their body. And so I'm looking at that blink rate and where their eye movements are going, visualizing, conceptualizing, and the rapid blinking. Or when their eyes are very focused, like something was asked that made them hone in, or if their eyebrows pinched together, if there was they were incredulous, or they were angry, or they were frustrated, or they were confused. All of that can be seen through their nonverbal communication. Huge in my eyes.
Yeah, so a lot to digest. Having Susan watch us, Robert, I'm a little nervous.
I'm watching you.
Yeah. Judge Chu is on the bench. Let's go in and listen. There's a panel of just 4 jurors in this group. Let's listen.
In Brooklyn Center, Hennepin County, state of Minnesota, defendant Kimberly Ann Potter caused the death of Daunte Demetrius Wright while committing the misdemeanor offense of reckless handling or use of a firearm so as to endanger the safety of another with such force or violence that death or great bodily harm to any person was reasonably foreseeable. Count 2 alleges second-degree manslaughter, and that count alleges that on or about April 11, 2021, in Brooklyn Center, Hennepin County, Minnesota, defendant Kimberly Ann Potter caused the death of Daunte Demetrius Wright by her culpable negligence, whereby Kimberly Potter created an unreasonable risk and consciously took a chance of causing death or great bodily harm to Daunte Demetrius Wright while using or possessing a firearm. The defendant has pleaded not guilty. That plea denies the charges and places upon the state of Minnesota the burden of proving defendant's guilt beyond a reasonable doubt. The state is represented by Attorney General Keith Ellison, Mr. Matt Frank, Ms. Erin Eldridge, and Mr. Josh Larson. The defendant is represented by Mr. Earl Gray and Mr. Paul Ng and Ms. Amanda Montgomery. I want to introduce to you other people that will play critical roles in this case. First of all, I have 2 clerks that will be assisting with all administrative matters. First